Parliament's authority remains intact. Judicial independence should not mean legislative paralysis. As stated in Order 1024 as being inadmissible. As required by Order 1024 of the Standing Orders, I provided reasons on the face of the proposed motion paper for my refusal to admit the motion. I've this afternoon been compelled by what has gone on in the course of your attempt to adopt the report of the Business Committee, and I'm to provide my reasons to plenary as part of my efforts to ensure full disclosure. This, as you all know, is an administrative function. It's not something that should be done on the floor of the House. But the way the deliberations has gone on, it has left not only members, but our constituents a bit unclear about how we conduct things in the House. So this is an attempt to clarify the issue and to bring finality to the matter raised by the minority leader. Honorable members, the Clerk to Parliament received the proposed motion on the 28th of October, 2025. As I said, it's a proposed motion. And so it's couched in the form of a motion by the minority leader, as required by the standing orders. It was forwarded to my office the same day. That's the 28th of October, 2025. My office at the Secretariat received it, and it was later transmitted to me. It was now my duty to administratively consider the admissibility or otherwise of the motion. In considering the admissibility of the motion, I was guided by the provisions of the 1992 Constitution, the standing orders of the House, and precedents of parliamentary practice. Honorable members, a motion as defined in Order 6 of the standing orders of this House is a proposal made by a member of Parliament or a committee to do something or order something to be done or express an opinion concerning some matter. Orders 102 and 103 vest discretionary powers in the Speaker to determine whether a motion is admissible or not. In exercising this power, the Speaker must be guided by provisions as stated in Order 103 of the Standing Orders to either direct that the motion be printed or the motion is to be returned as inadmissible. Honorable members, I have considered deeply the proposed motion. I considered the text and I concluded that there was no basis for me to exercise the discretion to admit the motion. I have a copy of the proposed motion here. The motion, in summary, suggests that Parliament, as an arm of state, should stay its hand until another cognate arm of state takes action on a matter pending before it, even when there is no definite time for that arm of state to take the action. I find this suggestion constitutionally and procedurally unsustainable. Article 144, Clause 1 of the 1992 Constitution gives Parliament a clear and continuing duty to consider a president nomination for Chief Justice. That duty is not conditional on events elsewhere. There is no constitutional or standing order simply because there are pending cases in court. Should I accept that argument, it will mean that any litigant could hold Parliament hostage, that is, file a case and freeze the work of Parliament and its committees. That would undermine the concept of separation of powers and paralyze the constitutional machinery for filling, for example, in this particular case, key offices of state. Honorable members, I'm very mindful of Article 2 of the 1992 Constitution, especially Clause 2 of Article 2, which vests the Supreme Court powers to make orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declarations it has made. This article clearly states that should there be any unconstitutionality regarding the removal of Her Ladyship Justice Tokunu, the court is vested with the power to so declare and make all necessary orders needed to restore the status quo. To that end, I'm of the view that courts can continue to hear whatever matters are pending before them, but until there is an injunctive order, Parliament's authority remains intact. Judicial independence should not mean legislative paralysis. In any case, I have consistently questioned whether the Supreme Court could use its injunctive reliefs to stultify the work of another arm of state. Is that the purpose of that relief? Honorable members, procedurally, I'm also mindful of Order 103, Rule F, which suggests that a motion shall not be a subject matter of an action in which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of the parties in the action. I have considered the provisions on admissibility of motion, and I submit that the proposed motion is out of order. As I have already indicated, I am convinced that the Supreme Court is vested with adequate powers to reverse any action should they deem them unconstitutional. This matter I have discussed with the minority leader who was bent on the motion being admitted. It's not that I'm just saying them now. But he gave me notice that he will definitely air his views on the floor. And I think that is why, as the majority leader said, even though you were discussing football, he brought in Ampe. In summary, honorable members, the major points of this ruling is that the motion is inadmissible, and same has been returned to the sponsor, the minority leader, Honorable Alexander Afenyo Markins, as stated clearly by our standing orders. I thank you all for your attention.